Hello, welcome to this webinar, the first in our series of Personal Injury Webinars 2024, Outlaw and Order, the Defence of Illegality in Personal Injury Cases. My name is Cassandra Williams and I'm a barrister here at Rope Chambers. Why have I chosen this topic? I was instructed to advise in a case a few years ago on behalf of a claimant. He had been involved in a road traffic accident. He was travelling at about 50 miles per hour when one of the wheels of his vehicle came off. He careered into a curb and sustained injury as a result. Prior to the accident, repairs had been carried out to his vehicle by the defendant. The claimant brought a claim alleging that the repairs were carried out negligently. Now, before the accident, the claimant's driving licence had been revoked, and the defendant argued that it was illegal for the claimant to have been driving his vehicle at the relevant time, and therefore his claim was barred by operation of the defence of illegality. Now, it had been a long time since I'd last dealt with a case where a defence of illegality was raised, and I needed to brush up on my law. It didn't take me long to realise, starting to navigate the law of illegality, that it was somewhat of a minefield. Each case appeared to establish seemingly different and inconsistent principles, and many of the cases involved the law of contract, and of course my case involved the law of tort. It was somewhat challenging identifying the principles applicable to my case, but I eventually found my way. This presentation will hopefully assist you in finding your way should you find yourself involved in a case where a defence of illegality is raised or where you're considering raising such a defence yourself. Please note that I will not be covering joint enterprise as part of this presentation, this being where a claimant is engaged in a joint criminal enterprise at the time when the injury is sustained. This area has its own discrete set of principles, which is outside the scope of this presentation. If you do wish to learn more about joint enterprise in the context of claims where a defence of illegality is raised, I invite you to consider the cases that I've put up on the slide. They would be an excellent place to start. So what is the illegality defence? It's born from the oft-cited words spoken by Lord Mansfield in the case of Holman and Johnson. No court will lend its aid to a man who founds his cause of action upon an immoral or illegal act. Lord Mansfield said that the reason for this was one of public policy, also stating that if from a plaintiff's own stating or otherwise, the cause of action appears to arise ex turpi causa, or the transgression of a positive law of this country, there the court says he has no right to be assisted. It is upon that ground that the court goes, not for the sake of the defendant, but because they will not lend aid to such a plaintiff. So what does ex turpi causa mean? The full maxim is ex turpi causa non fit injuria. Excuse my pronunciation to any Latin speakers out there. But that literally translates to the action does not arise from a shameful cause. Ex turpi causa meaning shameful cause. The words uttered by Lord Mansfield mark the start of more than 2 centuries of case law about the extent and effect of the maxim, which has the potential to provide a defence to civil claims of all sorts, including contract, property, tort, or unjust enrichment. Now, the law of illegality in the context of claims in tort has only relatively recently begun to develop. And one of the reasons for this was a reluctance by the courts to embrace illegality as an answer to a claim in tort. And this is because the consequence of applying the rule in a claim in tort is likely to have far more serious consequences than if applied to a claim in contract. As was recognised by Lord Justice Evans in Revell and Newbury, it is one thing to deny to a plaintiff any fruits from his illegal conduct, but different and more far-reaching to deprive him even of compensation for injury which he suffers and which otherwise he is entitled to recover at law. The Court of Appeal also remarked to deprive a wrongdoer of compensation in a personal injury case was tantamount to treating them as an outlaw, and that was stated in the case of Cross and Kirkby. So let's take a look at the case of Revel and Newbury. This was one of the earliest cases where the illegality defence was raised in the context of a personal injury claim. In this case, the defendant fired his shotgun at the claimant and his accomplice, who broke into the defendant's shed. The claimant was injured and brought a claim for damages for personal injury. The claim was defended primarily on the grounds of illegality, but the defence failed at first instance. The judge found that the illegality doctrine could only apply if the injury complained of was so closely interwoven in the illegal or criminal act as to be virtually a part of it, or if it was a direct, uninterrupted consequence of that illegal act. The judge found that the defendant's actions were disproportionate to the threat and that the necessary connection between the claimant's criminal act and his damage was not established. This decision was upheld by the Court of Appeal. The court's findings were that the cause of the injury was not the illegal activity of the claimant, but the defendant's overreaction, and that this was sufficient to break the called connection between the illegal act and the injury. This close connection test was adopted again by the courts in Cross and Kirkby, but this time the court found that the necessary connection had been established between the claimant's criminal act and the damage sustained, and the defence of illegality therefore operated as a bar to the claim. In this case, the claimant attacked the defendant with a baseball bat after threatening him. The defendant managed to wrestle the bat away from the claimant and struck him on the side of the head with a single blow, and this caused quite serious injuries to the claimant. The claimant brought a claim for personal injury, and the defence of illegality was brought by the defendant. The judge at first instance rejected the defence, finding that the defendant used excessive force. But the Court of Appeal overturned that decision, finding that the defendant was acting in self-defence at the time. Lord Justice Belden said that the principle applies when the claimant's claim is so closely connected or inextricably bound up with his own criminal or illegal conduct that the court could not permit him to recover without appearing to condone that conduct, and also found that the claimant's injury arose from his own criminal conduct. Further guidance on this inextricable link test was also provided in the case of Velino and Chief Constable of the Greater Manchester Police, where Sir Murray Stuart Smith stated that the facts which give rise to the claim must be inextricably linked with the criminal activity. It is not sufficient if the criminal activity merely gives occasion for the tortious conduct of the defendant. After Velino came the well-known decision in the case of Gray and Thames Trains, and Gray marked a departure from the inextricable link test. In Gray, the claimant developed post-traumatic stress disorder when he was injured in a train crash which occurred due to the defendant's negligence. While suffering from the effects of the post-traumatic stress disorder, the claimant stabbed to death a drunk pedestrian with whom he had had an altercation. The claimant was consequently detained under a hospital order. The claimant sued Thames Trains to recover for his loss and damage that he said that he sustained as a result of being detained and as a result of his loss of liberty. He argued that these were all caused by the defendant's negligence. The judge at first instance allowed the claim in part, and the defendant appealed. In reaching its decision, the House of Lords rejected the rules-based approach and with it the inextricable link test, applying instead a pure policy-based approach. The court identified that there was justification for a special rule of public policy, which could be expressed in both narrower and wider form. The narrower form of the rule being the need to avoid inconsistency in the law. Specifically, that as a matter of penal policy, if it is the law which imposes the damage which is caused by the penalty imposed, then the law cannot also compensate you for that damage. The wider form of the rule being that you cannot recover damages suffered in consequence of your own criminal act, which reflects the idea that it is offensive to the public notions of fair distribution of resources that a claimant should be compensated, usually out of public funds, for the consequences of their own criminal act. Both forms give rise to questions of causation. The narrower form causation question being, was the damage a consequence of the lawful penalty? The wider form, did the claimant suffer loss in consequence of their own criminal act? Approaching that question, Lord Hoffman recognised the well-established distinction between causing something and merely providing the occasion for someone else to cause something. This is the same principle in the law of tort, where even if but for the defendant's tort, the damage would not have occurred, the defendant would not be liable if the immediate cause of the loss was the deliberate act of a third party. The House of Lords in Grey found that the public policy expressed both in narrower and wider forms operated as a bar to the claim. The claimant could not be compensated for losses suffered as a result of a penalty imposed by the law, and further, although the loss would not have been sustained but for the defendant's negligence, it was the claimant's own criminal conduct which had caused it. The defendant's negligence had merely provided the occasion for the loss to have been sustained. It became clear from the cases following Grey, however, that the law of illegality remained in a state of disarray as the courts grappled with the application of the public policy approach to the defence. Enter Patel and Mirza, the long overdue and highly anticipated decision of the Supreme Court, hailed as finally providing clarity and order to the previously disordered state of the law. Now, the facts in Patel are not actually relevant for present purposes. It was a claim for alleged breach of contract and unjust enrichment. But in Patel, the court conducted an extensive review of the common law of illegality, highlighting the various principles that were established by the case law. And this led the court to the identification of what Lord Toulson described as the trio of considerations to which the court should have regard when determining the application of the defence of illegality. Lord Toulson, with whom the majority agreed, observed that the essential rationale of the illegality doctrine is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system. In assessing whether the public interest would be harmed in that way, Lord Toulson considered that it is necessary to consider the following trio of considerations, which I have set out on the slide. A, the underlying purpose of the prohibition which has been transgressed and whether that purpose will be enhanced by denial of the claim. B, any other relevant public policy on which the denial of the claim may have an impact. And C, whether denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. Lord Toulson recognised that within that framework, various factors may be relevant, but it would be a mistake to suggest that the court was free to decide each case in an undisciplined way. It was considered that the public interest was best served by a transparent and principled assessment of the considerations rather than a formal approach which may produce arbitrary, unjust, or disproportionate results. In the later decision of the Supreme Court in Henderson and Dorset Healthcare, the court confirmed that Patel was intended to provide guidance as to the proper approach to the illegality defence across civil law generally, and importantly confirmed that this did not mean that Patel represented year zero and that in all future illegality cases it is Patel and only Patel that is to be considered and applied. The court considered that this would disregard the value of preceding cases which had developed the illegality defence in specific factual situations. The court confirmed that the preceding decisions would remain of precedential value unless it could be shown that they were fundamentally incompatible with the approach set out in Patel. The facts in Henderson were remarkably similar to the case of Gray. The claimant was schizophrenic and she stabbed her mother to death during a serious psychotic episode after being negligently released from the defendant's mental hospital. The claimant brought a claim against the hospital, arguing that their negligence caused her loss and damage. The court applied the trio of considerations to the facts of the case and reached the same results as the House of Lords in Gray, and the claim was dismissed. The court observed that the essential reasoning in Gray was consistent with the approach taken in Patel, namely a policy-based approach. Now, it could be argued that this need to have regard to preceding case law has made the approach less clear-cut than what first appeared to be the case following Patel, and that is perhaps why the court in Henderson provided further guidance as to how to approach the application of the trio of considerations. Lord Hamblin divided each consideration into 3 stages: the first stage, or stage A, the second stage, stage B, or the third stage, or stage C, and I've set out those stages on the slide. Lord Hamblin confirmed that weighing up each consideration involved a balancing act between the considerations at the first and second stages. Stage A is directed at policy reasons supporting the denial of the claim. Stage B, directed at policy reasons supporting the denial of the illegality defence. Stage B is meant to operate conversely to Stage A. At Stage A, the court would have regard not only to the specific purpose of the prohibition transgressed, but would also need to have regard to other general policy considerations impacting on the consistency of the law and the integrity of the legal system. The third stage relates to proportionality, and the court would be concerned with factors specific to the case rather than general policy considerations. Lord Hamblin noted that if balancing the considerations at Stage A and Stage B, the result was the firm denial against the illegality defence, then it was not necessary to proceed to Stage C. The third stage was described by Lord Hamblin as a disproportionality check rather than a proportionality requirement. There were 4 factors of particular relevance to the question of proportionality: the seriousness of the conduct, its centrality to the transaction, whether it was intentional, and whether there was a marked disparity in the parties' respective culpability. Lord Hamblin regarded that centrality was a factor of particular importance and considered this to involve a question of whether there was a close causal link between the illegal act and the claim. The Supreme Court provided further guidance on the trio of considerations in the case of Gondogna and Stoffel, and that guidance is set out in the judgment of Lord Lloyd-Jones. I've set out the key part of that judgment on the slide. The court stressed that the evaluation of policy considerations undertaken at Stage A and B must not become another mechanistic process. The relevant policy considerations identified would be identified at a high level of generality before consideration of application to the present case. As has been stressed by the court previously, the central question was whether to allow the claim would damage the integrity of the legal system, and that question would not involve carrying out policy-based evaluations of the law. Rather, the court would first identify the relevant policies to which the law gives effect. Second, determine whether those policies would be undermined if the claim were allowed. Third, consider what relevant policies operated in favour of the maintenance of the claim. And fourth, assess the competing policies to determine where the overall balance lies. Stage C would involve close scrutiny of the detail of the claim. So we've now embarked on the intensive process of identifying the applicable law concerning the defence of illegality, and we've looked at the guidance as to the approach to take when applying that law. But that inevitably leads to the question, how does one apply all of that in practice? I consider that the case of Arrow and Gray is a very helpful example of this. It's the decision of His Honour Judge Bird sitting as a judge of the High Court. In this case, the claimant and his passenger were seriously injured when the vehicle that they were driving in struck a wall at speed. It was the claimant's case that he was trying to escape the first defendant and his companion, who was pursuing the claimant's vehicle at the relevant time. Now, there's no dispute that the first defendant drove his vehicle at speed, overtook the claimant's vehicle, swerved towards the claimant's vehicle and collided with it, which caused the claimant to lose control of his vehicle and crash into the wall. And the defendant was charged, convicted, and imprisoned as a result of his conduct. So what gave rise to the illegality defence? Well, before the accident, the claimant and his passenger were parked outside of a nightclub. The first defendant and his companion were outside of the nightclub, and the claimant and his passenger were shouting abuse at the first defendant and his companion and were behaving in an aggressive manner. On one occasion, the first defendant approached the claimant's vehicle and the claimant's passenger punched the defendant in the face. The claimant drove away from the scene, but then returned shortly thereafter to engage in further aggressive behaviour towards the first defendant and his companion. Having had enough by this point, the first defendant tried to open the door to the claimant's vehicle but found it to be locked. The claimant drove away, the first defendant and his companion ran to their vehicle, got in and pursued the claimant, and the events that gave rise to the accident unfolded. So what was the judge's approach? The judge first looked at the first stage of the trio of considerations, and I've put a reminder of what that says on the slide. It concerns the public policy justifying the denial of the claim. Now, in identifying the relevant public policy considerations, the judge followed the approach taken by the court in Gray and Thames Trades. First, considering the narrower form of the public policy rule, whether the damage was caused by the imposition of a lawful penalty, and the wider form of the rule, whether the damage was caused by the claimant's own criminal act. The judge considered that the claimant's conduct was disgraceful and could have warranted criminal sanction, but observed that the claimant was not prosecuted or otherwise sanctioned, and in those circumstances, it was difficult to see where any disharmony in the law might arise if his claim were allowed to proceed. The judge further observed that this is not a case where the claimant would have been profiting from his own wrongdoing. Indeed, any compensation he received would be to put him in the position that he would have been in had he not been injured. And this, seems to me, would be the case in all cases of personal injury. In addressing the wider form of the rule, the judge concluded that the claimant's conduct was not the cause of his loss, but that the immediate cause was the defendant's dangerous driving. The claimant's wrongdoing merely provided an occasion for the defendant to do harm. The connection between the claimant's conduct and the loss was not a close one. Indeed, the claimant was trying to escape from the defendant at the material time. The judge concluded that it was difficult to see the public policy justification for the claimant to go uncompensated for his losses, and that the public policy factors supporting judicial abstention were all but non-existent. As to the second stage, the public policy considerations supporting the maintenance of the claim, the judge considered it undesirable for the claimant to fall back on the state for any financial support that he might have required as a result of his injuries, and the transfer of financial responsibility from the tortfeasor to the public purse was an important consideration, justifying the rejection of the defence. Balancing the first and second stages, the judge considered that the factors supporting the maintenance of the claim easily outweighed the factors supporting the denial of the claim. It was not therefore necessary for the judge to proceed to the third stage, and this is something that the judge acknowledged. But helpfully for us, the judge did in fact conduct the disproportionality check anyway. He first looked at the seriousness of the conduct and was satisfied that the claimant's conduct fell towards the lower end of the scale of criminality, considering that the top of the range was represented by the kind of conduct carried out by the claimants in the cases of Gray and Henderson, namely homicide. As to the centrality of the conduct to the transaction, or here the loss, the judge concluded that although the claimant's conduct played a part in the events that gave rise to his injury, that conduct was peripheral and not central. The operative cause of the claimant's injuries was the defendant's deliberate action. The judge acknowledged that the claimant's conduct was intentional, as would probably be the case in most cases concerning illegality. Whether there was a marked disparity in the parties' respective wrongdoing, the judge considered that this was a key consideration. Whilst the claimant had engaged in deliberate criminal conduct, it was towards the bottom end of the scale. The defendant, however, deliberately executed an inherently dangerous manoeuvre which had life-changing consequences for the claimant, and indeed he was imprisoned as a result. The judge considered that it would be wholly disproportionate to refuse relief to the claimant in the circumstances, and that such a course would bring the legal system into disrepute and offend the public interest rather than promote harmony and consistency. In his closing remarks, the judge commented that it was difficult to imagine that the integrity of the law could ever be damaged by the courts coming to the aid of a seriously injured claimant if his injuries were caused by the negligence of the defendant. In taking such a course, the integrity of the law was far more likely to be damaged by a refusal to assist. The claim was therefore successful. So returning to the case then that set me on this journey in the first place, here's a reminder of the facts. The claimant was driving his vehicle at about 50 miles per hour. The wheel of his vehicle fell off. He crashed into a curb and sustained injury. His vehicle had been repaired by the defendant prior to the accident. The claimant's driving license had been revoked prior to the accident, and the defendant raised a defence of illegality. Would the fact that the claimant was driving without a license be sufficient to operate as a bar to his claim? Unfortunately, I didn't find out what happened in this case in the end, but it seems to me that if the courts had taken the approach that the courts had taken in the cases of Gray and Patel and Henderson and Grondona, the courts would not or should not have refused the claimant relief. Applying the trio of considerations to this case, looking at Stage A and the public policy rule in its narrower form, it was relevant that the claimant in this case was not convicted of driving without a licence, so it would be difficult to see where any disharmony in the law might arise if his claim were allowed. As to the wider form of the rule, there was no close connection between the claimant driving without a licence and his injury. The driving without a licence merely gave rise to the occasion for the loss, but the operative cause of the claimant's injuries was the negligent repair work carried out by the defendant. As to Stage B, the same sort of public policy considerations that were raised in RO and Gray would be relevant here. It would not be just for the claimant to have to resort to public funds for any financial support that he required as a result of his injuries. It would not therefore be necessary to proceed to Stage D and carry out the disproportionality check. If one did, the circumstances would be more finely balanced than they were in the case of RO and Gray, but it seems to me that overall the court would find it disproportionate to refuse relief to the claimant. Although the claimant's conduct in driving without a licence was probably deliberate, it would be towards the lower end of the scale of criminality. The loss was caused by the defendant's negligence. Although the offence of driving without a licence was deliberate, the defendant's conduct, although perhaps not deliberate in carrying out the negligent repair, could have had potentially serious consequences for the claimant and indeed caused him personal injury for which he was required to bring a claim. So overall, I consider it unlikely that the defence of illegality would have succeeded. So what can we take home from this canter through the law of illegality? I would suggest that the defence of illegality will rarely succeed in cases involving personal injury, which always seemed to be the position from the very start of the evolution of the case law. Patel has not so much as represented a change as to the prospects of such a defence succeeding, but has rather drawn together the disparate principles established in preceding case law into one unified approach. The case law suggests that the position remains that a defence is only likely to succeed where the claimant's own criminal conduct was the operative cause and not merely the occasion for the loss to be sustained. I finished this presentation by asking you to consider this. Let's return to the facts in RO and Gray, and instead, let's say the claimant had been pursuing the defendant's vehicle, and that the defendant had been trying to escape, and in doing so, he had swerved towards the claimant's vehicle, causing there to be contact, causing the claimant to lose control and crash and sustained injury. Would the claim still have succeeded on those facts? I will leave you to conduct your own assessment of the trio of considerations to those facts and see what conclusion you reach. Thank you for watching this webinar on demand. If you have any questions, my contact details are on the screen.